Hi everyone, welcome to our TazWorks webinar. We're excited to have all of you here and be talking about the GDPR and what that means for you as a CRA and what TazWorks is doing. We are going to be talking about a lot of different things today. But before we dive too much in, I wanted to just make a note that this webinar is being recorded. We will have that recording available tomorrow. So if you miss anything or if you want to share it with coworkers, that'll be available. We'll also have the slides available for you guys afterwards and a blog post write-up. So there will be resources available afterwards. So don't worry about taking notes on every single screen. And we will be opening for questions at the end. So if you submitted questions in advance when you registered, we're going to try to address those mostly as we go through this webinar and present on those different topics. But if you feel like something didn't get covered, you still have want some clarification, then you can submit those throughout the presentation and we'll just hold all of them until the end. So with that, we are going to move forward and introducing our presenters. So we've got two awesome people talking today. Kevin Abbott is a partner at the Cadence Group. We're really excited to have him here. He's going to be talking mostly about the GDPR in general, what that means, what it is, since it's pretty large and confusing to a lot of people. And then Natalie's going to talk. Natalie is our Director of Revenue Protection here at TazWorks. She's going to talk more about specifically what TazWorks is doing, how our software aligns with this, and some of the more specific implications of that. So with that, I'm going to turn it over. Kevin's going to talk a little bit more about his background and start going.
Thanks, Kayla. So as Kayla mentioned, my name is Kevin Abbott. I'm a partner at the Cadence Group. We are a consulting and audit firm. We have offices in San Francisco and Salt Lake City, Utah. My role within the firm is I oversee our information security and information privacy practices. So that includes GDPR. It also includes a few other practices that you or frameworks that you may be familiar with around compliance. So PCI, which is credit card security, SOC reporting, which is general third-party service provider reporting on data security. So those are the areas that I oversee. Today, I want to talk through GDPR in general. I'll start pretty high level, and then we'll drill down into some more specifics and commonly asked questions and try to bring some clarity to a regulation that's frankly not very clear. So that's my goal today. And then, as mentioned, Natalie will talk a little bit more specifically about TazWorks and how they're dealing with GDPR. So as I mentioned, let's start pretty high level. So GDPR, most everybody's heard of it. Everyone knows that it's becoming effective very quickly. The actual acronym stands for General Data Protection Regulation. In summary, it's a privacy regulation. It's specifically been put in place as a law by the European Union. I'll talk a little bit about how that stretches beyond just the EU and affects companies in the US and other parts of the world. But the GDPR itself, it replaces the old data privacy regulation for EU citizens that was around, created back in 1995. So we're talking, 23 years later, replacing a regulation. So obviously technology has changed. The way we deal with data privacy has changed quite a bit. GDPR was actually passed just about 2 years ago, so April of 2016, and becomes enforceable on May 25th. I imagine many of you are familiar with that date. On that day, it becomes enforceable. Again, it's been around for 2 years. There's basically been a 2-year grace period to prepare for and put appropriate practices in place to comply with GDPR. And on that date, it becomes enforceable, meaning companies can be subjected to audits and potential fines. We will also talk a little bit more about that. So who enforces GDPR? One thing that doesn't seem to be very clear with GDPR is who's actually policing this new regulation, and do they have the jurisdiction and the authority to come to a company within the US and impose a fine or other sanctions? And I will tell you, I don't have the answers to all those questions, and I don't believe anybody does today. When this standard becomes enforceable on May 25th and over the coming months, we'll learn a lot about how enforceable the GDPR really is and how that enforceability works. But the way that it's structured is each EU state is assigned a supervisory authority. So you'll hear that term, supervisory authority, or SA for short. They have been empowered to both investigate instances of non-compliance and enforce the regulation. So clearly it will be easier for those SAs to enforce GDPR within the European Union itself. Those companies within the EU are subjected by law to adhere to GDPR, but I'll talk about how it also applies to US companies in particular. So as far as impact of GDPR, I'm going to talk through a couple high-level points of how GDPR impacts companies both inside and outside of the EU. So one of the main things is a change or an increase in territorial scope. So previously, the old EU data privacy directive was really limited to those within the EU itself, or what is now the EU. Some of you may also be familiar with Safe Harbor. Safe Harbor was tied into that old data privacy directive and allowed countries such as the EU to have safe harbor principles and allow the data storage or data transfer outside of the EU. So there used to be very much a concept of data needed to be stored within the geographical borders of the European Union to be considered protected. Those borders really don't exist anymore, and GDPR does not require that data is stored within the EU. So the territorial scope of GDPR is automatically extended and extends not only to companies within the EU, but it extends to companies in the US and other parts of the world that are dealing with or storing or processing EU citizen data. So that's the key to GDPR, is if you are storing or receiving or processing personal data from an EU citizen, then you are subject to the GDPR and its regulations. One of the other main tenets of GDPR is a greater demand for breach notification. So companies, upon becoming aware of a data breach, are required within 72 hours to notify both the supervisory authority within the EU as well as customers. That's quite a change, and it's somewhat unprecedented as far as its scope. So reporting within 72 hours is fairly quick and becomes a subject of non-compliance if you report outside of that 72-hour period. One of the other main areas of GDPR is around consent. So this is probably the most talked about concept of GDPR, which is the concept of explicit versus implicit consent. GDPR now requires that you obtain consent from individuals before processing their data, before marketing to them. We'll talk quite a bit more about consent later on and alternatives to consent, but that is a main tenet, is obtaining explicit consent before processing somebody's personal data. By the way, I'm using the term personal data because that's what GDPR uses. It's essentially similar or equal to what we would term PII, or personally identifiable information. So those terms are somewhat interchangeable, but I typically use the term personal data. And speaking of, GDPR broadens what personal data means. So one of the difficulties with data privacy in general is there is no one single definition of what constitutes PII or personal data. Depending on which state you live in within the US, there may be state laws around it. Depending on which framework you're adhering to, there are different rules or reasons for why something is considered personal data or not. Unfortunately, that does not become crystal clear within GDPR, but what it does is it broadens what is considered personal data, where we would normally consider things such as somebody's name or their email or their address or their social security number clearly as personal data. Now GDPR extends that to some more obscure identifiers, such as cookies. So when you go visit a website, that website is typically tracking data on you. That is now considered personal data. Even things such as IP addresses. If I have a static IP address assigned to my computer and it could be linked to me as a person, that could now be considered personal data. So that's one of the main things people are concerned about, as well as the extension of, and broadening of what personal data now is. And finally, GDPR, the main goal of GDPR, honestly, is to empower data subjects or individuals and their rights. The point is that an individual such as you or I, or specifically an EU citizen, now has the right to know where their data is, what's being done with it. They have the right to have that data erased or withdraw their data from a company. Again, that's one of the main points of GDPR, is to empower the actual individual to be in control of their own data. And then the tail end of this, and what a lot of people have also heard about GDPR, is the very substantial fines that come along with non-compliance. So there's a couple tiers of violations, but the maximum fine here is 20 million euros, or 4% of a company's annual revenue. Those are staggering numbers. And that's why GDPR has received a lot of attention, is because of the potential huge fines that come along with non-compliance. Now, speaking pragmatically, we have information released from the EU and from the ICO, which is the UK's body that governs data privacy, basically saying we're not going to come out on May 25th and start fining people 20 million euros. Their intent is not to punish people, but rather to educate people and try to get people to comply. So it'll be really interesting to see what fines are issued, who they're issued to, the amount of those fines. I think this is enough to get people excited about this, to get people's attention, certainly. But I don't think it's a doomsday scenario where there's going to be $20 million fines or 20 million euro fines come May, or even within the next few months. So given that overview, I want to get into some specific questions that I've encountered frequently that our clients have asked. And I hope to shed some light here around, now that I know what GDPR is, how do I comply with it? What are my responsibilities? And again, I don't know everyone who's on this call, but I imagine most are US-based companies. So again, this does extend to companies in the US or companies outside of the EU if you are processing or storing personal data of an EU citizen. So if you're working with a company that's in the EU and doing employment screenings for their employees, then you absolutely fall under the umbrella of GDPR. So I want to take a minute and talk about how do you validate compliance with GDPR, and how does that compare with some other standard frameworks that you may be familiar with? On the screen, I've got a continuum, and on the left-hand side would represent effectively immature validation and compliance processes, and on the right side would be more mature. So a couple criteria here, or a couple highlights within these frameworks. So PCI, again, is the credit card security framework. It's put together by the credit card brands like Visa, MasterCard, and American Express. And it's a very mature standard. It's been around for about 15 years now. They're very well-defined levels and requirements depending on the type of company that you are. There's a very defined process for undergoing an audit and issuing an assessment, a report. It's very standardized. They have designated and certified audit firms to perform those assessments. It's very black and white. There's very little ambiguity there. SOC reporting is the same way. There's a very defined standard as to what's expected. The reports that come out from those assessments, a SOC 1 report or a SOC 2 report or a SOC 3 report, are very standardized. They look very similar from one company to another. So I would consider that a fairly mature framework as far as validation. When we move back down the spectrum, HIPAA is another framework or a law that many of you are probably familiar with. HIPAA deals with the protection of health information of an individual. HIPAA and GDPR, in my mind, have a lot of parallels. HIPAA's been around for a long time. It is a law. It was issued by the US government, and its enforcement is difficult, to say the least. There's not a really good methodology or program for to undergo an assessment and issue a standardized report to say that we're HIPAA compliant. Everyone knows what it is, and healthcare companies especially certainly have incentives to comply with it, and there have been instances of audits and fines for non-compliance, but they're very rare. And GDPR, at least today, to me, is very similar to HIPAA. The enforcement, and again, I'm projecting some of this. Nobody knows for sure how it's going to play out, and we'll see certainly over the next year. We'll have more information, obviously, 6 months or a year from now. But at least today, GDPR and HIPAA are very similar in my mind, and we'll see how that plays out. Some have also compared it to Y2K. For those that were around back in 1999, you remember a lot of excitement and a lot of angst around what's going to happen when the clocks turn to the year 2000. Are all of our computer systems going to break? Can they handle this? There's a little bit of a similar feel with this May 25th deadline, and I feel like there will be a similar result. Come May 25th, not a lot's going to really happen. It will become enforceable at that point. But as I mentioned earlier, my view, and I should state this is my opinion on this, but I think many share this opinion, that the goal of the EU Commission and the ICO and others that are going to be enforcing this is we want to educate companies. We don't want to necessarily come out and punish companies right out of the gates, but we want to make sure that people understand the goal of GDPR and are on a path to be in compliance with it. So I hope that sheds a little bit of light on validation. There is no, with GDPR, there is no audit report. There are no audit firms that are designated to perform an audit and issue a report. So if your question is, which is a very common question, how do I show that I'm compliant with this? There is no way today to officially, from a third party, show that you're compliant. Now, you may have a third party firm come in and do an assessment, and they will devise some form of criteria, or in their opinion, say you're meeting the GDPR requirements or not. But what they issue to you, there's no official sanctioned accepted report. I hope that makes sense. So for the time being, we're all relying on effectively a self-assessment, and we're doing these assessments and trying to be compliant with GDPR effectively for two reasons. One, clearly to avoid a fine, a non-compliance fine or a sanction to some degree, and also, especially for those on this call, we're also becoming compliant with GDPR to enable our customers to be compliant. As a service provider, whether you're in TazWorks or a CRA, you have a responsibility to the customers that you work with to be compliant, to help them to also be compliant. Okay, this next slide talks about data processors versus data controllers. And this is also a misunderstood concept. So I wanted to give a little example here. On the screen, you can see 4 columns. And if we start up at the right, if we start with a data subject, this is an individual, an employee. Let's say an employee of company ABC who is based in the EU. Let's say they're based in Germany. And this employee works for company ABC, and their employer wants to run a background check. And their employer, in this case, functions as the data controller. They're the ones that are making decisions about what to do with the personal data of their employees. And let's say that they work with a CRA to perform that background check. And that CRA uses TazWorks as the platform in which to perform and store the data of that employee. So with that groundwork, then let's understand who's a data processor and who's a data controller. In this case, the CRA would function primarily as a data processor, as a service provider. You're performing a service for your customer, who's the employer, and you are becoming in possession of that personal data of an employee. But you're only doing so under the direction or the instruction of the employer, which was what makes them, by definition, a data controller. You, as the CRA, act under the instruction of what the data controller wants. They ask you to run a background check on these 10 employees, then you do so. TazWorks in this case also functions as a service provider, providing a platform or a service to the CRA to assist in providing that service. So hopefully that makes sense. By definition, a data controller is the one who decides what happens with personal data. A data processor receives instruction from a data controller and does not make decisions on what happens with it, but again, is acting under the instruction of the data controller. All data processors, and data controllers have a GDPR responsibility. Again, in TazWorks situation, they want to be compliant, both to avoid a fine, but also to allow their CRAs to be compliant. As a CRA, you want to be compliant for the same reasons. You want to allow your customers, the data controllers, the employers, to enable them to be compliant as well with GDPR. One thing that they'll be doing is they assess their own internal compliance with GDPR is they'll look at their service providers. And invariably, the service provider that they use for running background checks will show up and will be within scope for their own compliance. Let's talk about consent. So consent is largely understood as the method by which you gain permission from someone to do something, right? In this case, to receive or to process their personal data. Consent, however, is just one of 6 ways that a company, whether a data processor or data controller, has what they call a lawful basis for processing that data. Consent is the most commonly used, but I want to talk about the other 5 ways that you can go about receiving data or having a lawful or legal basis for which to process that data. So those 6 ways are consent, contract, legal obligation, vital interest, public task, or legitimate interest. On this screen, I know there's a lot of, this is a busy slide, there's a lot of words here, but this is an important concept, so I'm going to spend a minute here. Consent, as we talked about, is the most common. When I go to a website and I'm using that website, likely today you'll now see, or in the near future, within the next month or so, you'll see more requests for me as a user of that website to explicitly grant my permission for them to track cookies or to take my information. You'll see boxes that are no longer pre-checked. That's one of the requirements for using consent is you cannot have a pre-checked box. You have to have an open box that makes me as the user take some action to check that box to explicitly give my consent to do something. If there's a form field on that website, there needs to be an indicator somewhere that says, I am giving permission for you to use my personal data. And as the company or the owner of that website, I need to also explain to the user how I'm going to be using their data and be very clear about that. So that's how consent works. Again, the topic of consent is not new, but the change is that it requires explicit consent now. There are other ways to obtain a lawful basis that are outside of consent. If you have a contract with somebody, certainly that acts as consent as well. If they've signed a contract that allows you to obtain and do certain things with their data, a contract certainly appeases that. A legal obligation, if you have, and obviously there are certain use cases for this, but if you have to process somebody's information from a legal standpoint, then you don't need to have necessarily their explicit consent. If you can show a legal obligation to do so, to have that data and to process it, then that is fine. Vital interests, so consider police stations or fire stations that have to process somebody's data or have somebody's data to protect somebody's life, then that's a valid basis for processing. Public task deals with public interest for official functions. We deal more with public entities in that case. And then the last one is interesting. It's legitimate interest. If you can show that you have somebody's data because they have a legitimate interest in using your product or service, then you can use that as a basis for having and processing their data. This one will be interesting because it's a little bit of an umbrella catch-all basis. I hope and I would expect that some people may try to abuse this last one, legitimate interest, in place of getting somebody's consent and claiming that they must have a legitimate interest or we don't have their data. But to use this legitimate interest as a valid basis, you need to perform an internal assessment to show that the reason we have this data is due to a legitimate interest. I realize some of this may be confusing and I'm going through it rather quickly, but I did want to touch on this very important topic of what is the basis for you, what is your lawful basis for obtaining or processing somebody's personal information, and that there is more than just explicit consent as an option. A couple other questions that I wanted to touch on before I hand this over to Natalie, and then we'll have time at the end to go over their questions as well. What's a DPO? A DPO is a data protection officer. That term has also been thrown around as a new required position through GDPR, but it's not required for all entities. It is required if under a couple conditions. One, if you're a public authority. Two, if your core activities require large-scale, regular, and systematic monitoring of individuals. So if you do online behavior tracking or a data analytics company, then you would be required to have a DPO. Or three, your core activities consist of processing special categories of data. Special or sensitive categories of data would be if you have data on dealing with somebody's race, ethnic origin, politics, religion, health, sexual orientation, etc. What they consider sensitive categories of data, then you would need a data protection officer. What that involves is the official appointment of a DPO within your company and designated responsibilities to that person for monitoring how you track or how you process and how you store somebody's personal information, and making sure that you're adhering to GDPR. Next question, how does GDPR relate to Privacy Shield? So Privacy Shield has been in place for a couple of years. It's be easier to say that Privacy Shield replaced Safe Harbor and is a means by which that allows for data transfer between the EU and the US. So if you do Privacy Shield, does that exonerate you from doing GDPR? No, it doesn't. Privacy Shield ties into GDPR and again allows for that data transfer. We'll talk about this in a little bit more on this slide here. There's a lot of questions about data portability and international transfer. As I mentioned earlier, GDPR is less about confining that data within the EU. There will be some companies for sure that still want their data kept geographically within the EU, but that is not a requirement of GDPR. GDPR allows for that transfer between countries under a couple of conditions. The European Commission has recognized a few countries, and I've listed them here, that have what they deem to have an adequate safeguards for transferring that data. The US is on that list, as are a couple of other countries, but it also requires that Privacy Shield be enabled for that data transfer. So going back to Privacy Shield, that's a self-certification that you can opt into. And essentially you're saying that we have adequate safeguards to transfer that data and to store that data. So again, close cousin to GDPR, does not replace GDPR. Natalie, with that, I will pass that over to you. And again, there'll be time at the end of this for more questions, and I'll be happy to answer questions that come up after Natalie's done.
All right, thank you. My name is Natalie Mirando with TazWorks. I've been with TazWorks since October of last year, and my role here is focused on compliance. I've been in the screening industry for many years, which has given me a great deal of experience with the FCRA and the role of a CRA. I do currently serve on the Litigation Avoidance and Best Practices Committees for NAPBS, as well as some special task force charged with reviewing documents that are within the library currently. And we're really excited to be hosting this webinar today on GDPR and really appreciate your time. So know that TazWorks continues to map the requirements of GDPR, and as Kevin went over, our role is a processor or sub-processor. We currently have an EI3PA, which is an Experian Independent Third-Party Assessment Certification. We do hold the PCI DSS, which is a Payment Card Industry Data Security Standard certification. And most recently spent the past 8 months going through a very rigorous audit process to verify and enhance our controls for SOC 2 certification, or as it's more formally known as Service Organization Control 2. This audits against various organizational controls related to security, availability, processing integrity, confidentiality, and privacy. And these controls support both operational and technological safeguards around the services that we provide to you. As Kevin mentioned, this is a self-assessment for GDPR compliance at this point. We have been conducting self-assessments. We've not seen any deficiencies, but know that we're continuing to work with our auditors to map the requirements. And since some of these are a work in progress, again, as Kevin mentioned, we're going to continue to follow new developments in this area. For those of you attending user group in May, you may also want to attend the session on accreditations and audits to help you understand what these certifications mean in greater detail and how they can help you with your audits and your RFP processes. And at the end, Kayla's going to talk through some tools that we have for that. So based on the questions that we received, Kevin's gone over some of these pieces, but the focus area that we wanted to touch on from TazWorks perspective are disclosure and forms and opt-out, breach notifications, data erasure and portability, and privacy impact assessments. So let's first talk through disclosures and forms. You should be aware of the requirements, but know that some of these are still being defined in greater detail, and we are going to continue to monitor new developments on interpretations. As Kevin mentioned, consent must be given in an intelligible and easily accessible form with the purpose for the data processing attached to the consent. The data subject should have the right to withdraw consent at any time and must be informed of this right. It should be as easy to withdraw consent as it was to give it. And again, the consent must be freely given with explicit, clear, and plain language. So very similar to the current FCRA requirements. Things you'll want to look at potentially including with your disclosures are going to be making sure that you've identified yourself, the company, potentially any other third parties that you may work with who may process a data subject's information. You'll want to make sure that the purpose of the processing and the legal basis for the processing is included, which again would be obviously background screening. You'll want to look at the categories of personal data that you're going to be checking. Some sample forms tend to include many different pieces that may be checked. You may want to work with the companies you're doing background checks on and be specific in this area so the data subject understands what you're going to be processing on them. You'll want to look at your retention periods and the criteria used to determine the retention period. Most CRAs cover this information within their user agreements that you would have in place before you begin conducting background investigations for a company. You'll also want to look at the existence of the data subject's rights, that those rights are understood. Similar to the FCRA, again, they've got a right to request a copy and to correct inaccuracies. And like Kevin spoke about, the right to lodge a complaint with a supervisory authority. Again, that can vary by country. So make sure, the summary of rights is going to be included, but just make sure that you understand there may be additional information depending on the country as it relates to somebody understanding where they may go and who that supervisory authority is going to be. So to go back to withdrawing consent at any time, TazWorks does have decline functionality within its systems as people are going through the Quick app. But it'd be a good idea to talk through with your end users about an opt-out policy or process and how you may think through managing that with your end users. TazWorks does have the option to use and create custom disclosure forms, and you may wish to consider using a different form other than the samples that we currently provide in the system. Know that we are in the process also of improving this functionality, and we fully expect this to be launched out in Q2. So let's go on to breach notifications. As Kevin mentioned, there are different breach notifications from GDPR, then those vary based on here in the United States. So unfortunately, that also varies by state. So different states have different notification requirements, and some states are looking at the way that those notifications currently exist, the legislation surrounding those, and in light of the recent Equifax breach, there's been a lot of talk of potentially revising those. But in almost every case, the United States defines that as unauthorized exposure of data. GDPR, on the other hand, is very specific. There are some certain exceptions, but basically within 72 hours of there being a data breach, you need to have your action plan in place on that. It's also much broader in scope, and it includes accidental or unlawful destruction, loss, alteration, or again, unauthorized disclosure of personal data. So let's talk through our next slide, which is data erasure and portability. So Kevin touched on this a little bit, but know that this can't conflict with your FCRA requirements on your data retention policies or the policies that you have in place with your end users. So this is another area that is subject to some interpretation that we are going to be watching. You'll also want to think bigger picture than just your reports. In some cases, if somebody is requesting data be erased, it's not realistic to think you're going to be able to go to the court and get that data erased for them. So that's why some of this is not completely spelled out yet, but know that you may get these requests, and that also relates to the portability of the data. But really, make sure you're looking at your FCRA requirements to safeguard data if the question of portability comes up for you. And again, make sure you talk through these processes with your customers. We are going to move on to another area of GDPR, privacy impact assessments, or PIAs. These are required under GDPR, and it's a sound best practice to have written policies and procedures. So think, when was the last time you conducted a risk assessment with how your employees are processing reports, how companies are sending you data or communicating with you about a subject's data? How are you safeguarding the data? Look at what you're responsible for and understand that you should be able to demonstrate that you safeguard it. Certainly that expectation exists. Rather than just say, here's what we do, you should be able to show someone as well. Written policies and procedures can help you identify potential problems. It's going to create awareness at your company surrounding the safeguarding of this data and the other pieces that you're responsible for, and it's going to help you comply with GDPR. So with that, I'm going to turn this back over to Kayla, and we will talk through some questions.
All right, thanks to both of you. That was a huge amount of information on a really large topic. So thank you for covering and walking through all of that. I think that was really great. We are going to start with a couple questions for Kevin. The first one is, does GDPR apply to a US-based company wanting a CRA to do a background check on an individual with overseas work experience or educational background, but they're working in a US-based company and the job will be in the US, but they do have some overseas experience. They've lived in Europe before.
Good question. So their experience doesn't necessarily matter, or where they have lived. It depends on their citizenship. So if those employees are EU citizens, then they would be subject to GDPR. I fully recognize it's not always feasible or easily feasible to understand everybody's citizenship. People may have dual citizenship. There's a lot of quick problems that you run into in trying to scope this, but that is the letter of the law as it applies to EU citizens.
Great. And then another one was a follow-up on the data protection officer, or DPO, and whether they need one or not. They didn't say this here, but I assume they must be processing background checks on EU citizens in order for this to even apply. But they said, related to, you mentioned large-scale processing as a one of the requirements, the third one there. How do you define large-scale processing, and how do they know if that applies to them or not? If they're dealing with criminal convictions, does that mean it automatically applies, or how do they figure that out? And the answer might be that they just need to talk to their legal counsel, but I'll let you address that if you've got any specific thoughts.
Yeah, really great question. There's a lot of questions very similar to that, by the way, that I don't have answers to, nor are there answers today. This unfortunately is one of those where there is no definition of large scale. There's no quantity threshold that they've said if you process more than this, then you qualify as large scale. So there's some discretion there. If you're processing data that has to do with criminal convictions, then that falls under the category of special data. So you would need a DPO in that case, regardless. And so hopefully that answered the question at least as best I could. But one more thing on the DPO. Of all the GDPR requirements, appointing a DPO is fairly trivial compared to some of the others. So I would say if you're on the fence about it and you're not sure, it's probably a good idea just to do it. Designate a person. There's a lot of benefits that can come by designating somebody. It doesn't necessarily mean, by the way, that you have to go hire somebody. You don't have to have a person solely, their sole responsibility is functioning as a DPO. This could be an existing privacy officer or a legal counsel or a security officer. It's really just specifically designating someone as having responsibility for functioning as a data protection officer. So I think it's, in my opinion, it's a good idea if you're on the fence or not sure whether you're required. I would err on the side of appointing that DPO.
Just to reiterate one of the questions that we received, we did cover this to some degree, but reiterating that do we have a certification to prove that TazWorks or the CRAs are GDPR compliant? Is there any way that we can demonstrate that?
Yep, so thank you, Kayla, for that question, because we are getting that and we're having people send those pieces into support as well. Just to reiterate, there is no certification that you can receive, as Kevin mentioned right now. Now, there may be something that comes out down the road. As we've done our self-assessments with our EI3PA, our PCI DSS, and our SOC 2 certifications, we have yet to see something that is a deficiency that we would need to correct. Because this is a work in progress and we fully expect that different pieces may end up coming out on this, like the Cadence Group, we are closely monitoring any new guidance that will be issued. And we expect that there will certainly be new guidance issued. But right now, just to reiterate, we have not seen any deficiencies.
Okay, and so that probably addresses the other question, but just to ask that one as well to make sure that it is dealt with. Is anything going to change in the TazWorks system, or is, do we feel like we've got everything in our system that covers and addresses that?
So again, right now, we don't see any deficiencies, nor will we be making any changes with the current certifications that we have. We have undergone very rigorous audits to make certain that we have our controls in place, and these controls are very far-reaching, and we feel that we are, at this point, compliant and have not noted any deficiencies.
All right. So, Kevin, I've got another question for you. With the UK leaving the EU in next year, are they still included in the GDPR if a CRA is processing background checks on UK citizens but nowhere else in the EU?
Yes, the short and easy answer to that is yes. So that the Brexit process is not completed yet and won't be for I would guess another year or two. When it does, things may change, but the EU, or excuse me, the UK, one is they'll be subject to it because they're part of the EU on May 25th. But the UK has also been very proactive in supporting these data privacy initiatives. They will continue, unless something drastic changes, they will continue to support it and will be subject to GDPR going forward. In fact, the UK has a really robust information network around data privacy. The ICO, which is the Information Commissioner's Office for the UK, has been a really great source of information, Q&A, really pragmatic information around GDPR, if those two terms can even be used together. The ICO for the UK is really great that way. So I would recommend, if you've got further questions, I mean, my email address is here. I'm happy to help if there's specific questions after this, but go to the ICO's website and they've got a wealth of information and tools. They've got questionnaires, they've got things to help companies to understand and navigate through GDPR.
All right. So this is another one, and some of these I'm going to raise a couple of them. Kevin, feel free to decline on some of these, and some of them may apply directly to the CRA needing to work with their legal counsel. But if someone provides consent and then withdraws it after the background is in process, is there how should a CRA deal with that?
Yeah, good question. So I confess I'm not an expert on the laws as far as data retention for background checks and what a CRA is required to keep, if anything, after that background check is run. But in general, GDPR requires explicit consent. We've talked quite a bit about that. So that's not news, right? To run a background check, I believe that consent's always been required. But if a data subject, an individual, says after that check is done or while that check is in process that they want to revoke their consent, one, that needs to be done through their employer. So if you go back to or picture the slide I had earlier about that data flow between an individual to a data controller to a data processor. Again, I don't understand all the data flows in your particular industry, but generally that request would need to go through their employer, and that employer would then communicate it up to the CRA. If they revoke their consent, and they should have the right to do so, then again, generally speaking, then that data processing should cease and their data should be removed. But again, this is something I wanted to touch on earlier, and I don't know if it was clear. If you have a legal obligation to keep somebody's data, even if they've requested it be removed, then that legal obligation overrides that individual's consent or revocation of that consent.
Great, thank you.
Yeah, and I just want to hop in on that question as well, Kayla. I would echo that, and like we talked about when I went through disclosures and forms and the opt-out, it would really be best if you are subject to GDPR that you have a opt-out policy and process in place for that. But again, this can't conflict with your FCRA obligations or state regulations that would require you to retain someone's information for a period of time.
Awesome, thank you. All right, I think we've got a couple of questions, but I think they've mostly been addressed in those other ones. If you don't feel like your question has been addressed, then we've got contact information here for compliance@tazworks.com and Kevin at the Cadence Group TazWorks.com. So you can reach out to them and follow up, ask more information if you would like to. We also will be, for those of you who missed this at the beginning, we will be sharing a recording of this webinar tomorrow, along with the slides will be available for you to download and review, and a blog post recapping a lot of the same information. So we are making these resources available to you. And if you don't know already, we also have an entire support site for you guys to be able to access more resources like this. If you go to TazSupport.com, then we have a full knowledge base with hundreds of help articles on how to use our system, as well as some additional information that can help, like RFP requests and the data information that we have related to that, which we will continue to update as new legislation like GDPR comes out to help you respond to those kinds of things. So go to TazSupport.com. Some of that information is hidden to only TazWorks CRAs, so you will need to log in for some of that, but a large majority of it is available to anyone. So we recommend that. It also allows you to be able to, submit tickets and manage all of those, chat live with our support team. You can follow our software news posts and even get them delivered daily in your email, whatever. So there are a lot of options there to be able to follow up on. So with that, we're going to wrap up. Thanks everyone for joining. It was great to have you here. Thanks especially to Kevin and Natalie for all of the valuable information that you've provided. And we will be sharing this recap with all of you guys tomorrow. Thanks.